If I had a chance to tell one thing to injured employees about workers' comp, it would be they need to at least consider talking to an experienced attorney as soon as they can after their date of injury. I'm Jack Knowlan, former administrative law judge with the Division of Workers' Compensation, now a partner in Little, Shellhammer, Richardson, and Knowlan. I limit my practice to workers' compensation cases. Our job is helping the injured and disabled. That's what we do. All those years as a workers' compensation judge has given me the experience and the contacts and the knowledge to be uniquely well qualified to represent employees. Everything from knowing what the statutes provide and how the courts have interpreted them, and more importantly, how our local judges interpret those statutes and apply them, how those judges value the cases. For 22 years, mostly what I did was mediations, helping people resolve their claims, and hearings. That experience translates into me being in a much better position to help employees get their cases settled quickly and hopefully for a reasonable amount. Talking about changes in the workers' comp system, from 1986 until 2005, they had legal advisors, and they were appointed to help unrepresented employees get their cases settled so they wouldn't need to hire an attorney. Over the years, the employer side began to kind of resent the legal advisors because they thought they were recommending settlements that were higher than they wanted to pay. So when they changed the statute in 2005, they did away with that position. I saw that as it was great for the business community in terms of the value of the settlements, but it was really a disadvantage for the injured employees because they didn't have any help anymore. It's not really a fair playing field anymore since they did away with the legal advisor position. That's one reason why I think employees need to consider at least talking to an attorney and try to pick somebody who limits their practice to workers' comp. In Missouri, the employer gets to pick the doctor. And so they have control over the medical treatment and that they get to pick who the doctor is. And a lot of times the doctors become dependent on the referrals from the employers and the insurance companies. And so in some cases, not all, that begins to affect their opinions on causation, on whether somebody needs more treatment, or how much disability they have. So the employees, this isn't our word, but the employees call them company doctors. And the company doctors in most cases do a great job, but there are cases in a close case where they're going to lean in favor of the employer-insurer on issues of causation, on issues of additional treatment, and also on questions of how much disability they have. So the employees don't know that, and frequently, though, when they finish with the company doctor, they're not as well as they'd like to be. They're still having a lot of symptoms, and they come to us to try to help them get more treatment. And we do work really hard to get our clients second opinions if they need them, to make sure that they don't need more treatment before they start talking about settling their case. The system really does stack up against them on the valuation and the settlement of their cases. If they go in without an attorney on these conference dockets, they're going to be up against an attorney from St. Louis who specializes in workers' comp, and that's all he does, and he's being paid to get that case settled for as little as possible. He can't represent two people at once. That's a conflict of interest. And in terms of the value of the case, the judges have been told that unless both sides agree, they can't give an opinion on the value of the case. They will always have a rating, or almost always have a rating from their company doctor. That's an AMA or orthopedic guide rating. It's usually significantly lower than what the actual value of the case would be if a judge got to decide it. And they normally don't explain that to the injured workers. So they think that they're getting as much as their doctor's rating. They think that's a reasonable settlement. Unless it's ridiculously low, the judges can't do much about it except recommend they get an attorney. So that's very tough for them without some help to get a settlement that I would call reasonable in terms of value. And that's where me having been a judge is very important, because when I first started, the settlements were kind of all over the map. and we would see one guy with a operated knee getting 10%, another guy would get 20%. And so we said, well, let's come up with some general guidelines for what these injuries are worth. And with help from the other judges, we gradually developed these guidelines about what these cases are worth for an average to good result. And I know those, and I know how those judges value their cases, and I'm pretty good at predicting what would happen if we had a hearing. And that's what we primarily use as the most important factor in deciding how much we're going to ask for and how much is going to be enough. We want to get in that same range that a judge would put them in if they had a hearing, but not have to go through the expense and the time of having a hearing. I think after 36 years, most people are ready to call it quits and go fishing. And I've thought about that, but I really feel like I'm just hitting my peak in terms of what I can do for the clients that we represent on workers' comp cases. I can't help them with their divorces or bankruptcies or wills, but I can in a workers' comp case. And so many of these people really need help. They have lost their paycheck, and a lot of them live paycheck to paycheck, and they don't have health insurance. They can't get treatment, and they're counting on us to take care of them and get them the benefits they're entitled to. That's the reason I'm still doing it, because I still feel very confident that I can help, and I still enjoy helping people.